Good morning, good morning, good morning. Thank you for joining us on this masterclass, which is estate planning. My name is Elizabeth Buko. I am a financial coach. I help women change the way they think about money so they can start building wealth. And today I'm joined again with the amazing Mariah Thomas.
Thank you so much.
She is just an amazing financial advisor and estate planning advisor as well. And today she's going to talk to us a bit more about estate planning. I'll let her introduce herself. Hey,
Thank you, Elizabeth. Good morning, everybody. So my name is Maria Thomas, and I am an insurance protection advisor as well as an estate advisor. So what does that mean? It means that I've helped many hundreds of individuals and families to protect their wealth, gain wealth through insurance products, and then to very carefully and considered leave a legacy for those that they want to leave behind and to have their wishes laid out and planned as well. So that's what I do on a day-to-day basis. And I'm really looking forward to helping you to gain some knowledge around what I do and how to put things in place yourself. So thank you for coming on board.
Oh, amazing. Thank you so much, Mariah. Okay, so guys, if you have any thoughts, any questions that you maybe that comes to your mind during this session, I'll encourage you to write it down because we'll have a quick Q&A towards the end. But first, before we start, I want us to put in the chat, when you hear the words estate planning, what comes to your mind? Or you hear the word will, trust, power of attorney, what comes to your mind? If nothing comes to your mind, that's right, just say nothing. If you're confused, write confused. If you are apprehensive, or just tell me in the chat so we can know where everyone is, how everyone's feeling about the topic. What comes to your mind when you hear the words around estate planning, wills, trust, power of attorney? So let me know in the chat. Mariah, for me,
yeah,
I first started thinking about wills. I used to feel very apprehensive, like, and
yeah.
I remember when I was I think in my early 20s, I wrote my first will. And but don't clap here, because the reason I wrote it was to just kind of like see how people will be triggered when I say, oh, I've written my will. Crazy. Because I knew that it created the same feelings amongst most people. Now I know better, like have a better idea of why I need a will or what a will is. But at that time, it called morbidity to me.
Okay.
Like,
that's a very unusual motivation, I must say. I also wrote my first will when I was 23, but I was triggered through loss. So I had recently lost my mother, and losing somebody that close to you makes, death real, So for me, and because I was a mother myself at that point, it made absolute sense for me to write my will. So it's no surprise that I have a real clear passion for what I do and why I do it. And I also speak from personal experience when I talk to people about planning and, getting themselves protected, because I've lived through loss, and it's important for us to have that level of control while we can. But yeah, a will does spark a lot of connotation with people. And in our culture, let's face it, a lot of it is around fear. A lot of that is around tempting fate as well. So I'll be interested to hear what people have put in the chat when you've asked that question. I think it's a great question.
Yeah. So let us know when you think of wills, or the first time you heard wills, estate planning, what was the first thought that came to your mind, or the first emotion that made, what emotions came up for you when you think about that? So today we're talking about key steps to estate planning.
Okay.
And we're calling it key steps because it's not something that is just set aside for like wealthy people. We always, when you do know that, okay, wealthy people have an estate, they have a plan for their estate, they have a trust, but it's not just for them, right? It's for everyone. Everyone needs a will. Everyone should understand what having a trust should do. So when we're thinking
Yeah.
of these steps, Maria, tell us a bit what you think these steps are.
Okay. I'd like to start this masterclass off by just giving people a bit of a quote that's on my wall in my office, and it's one that I look to every now and again. Those who died yesterday had plans for today, and those who died today had plans for tomorrow. So when we think about planning for estate planning and things like that, yes, we're thinking about death. And a lot of the time, and in most circumstances, we don't know when that's going to happen. But with estate planning, it gives us control over planning and being considered for when the inevitable comes. So I just want that to rest with everybody. Now, for me, in the industry, I like to think that there's three pillars to estate planning and three pillars to protecting our finances and our wealth. And the first pillar is insurance, having the right level of insurance in place to gain wealth in most instances, and then to protect your wealth. The second pillar is to have a lasting power of attorney in place, and there are two, one for health and welfare, one for property and financial. We're not going to cover too much on that today, but it is important for me to mention because it is the second in the pillar. And the first pillar being insurance and the second being lasting power of attorneys are things that we put in place for while we are still alive. And the third pillar is wills, trusts, will-based trusts, things that you're putting in place for when you've passed away. So there's three key important steps that are involved in estate planning. So if you're seeing financial advisor or a wealth planner or even an insurance advisor, they should talk to you about wills or LPAs. If you're seeing me because you've come to me to talk to me about a will, I will talk to you about insurance and LPAs because they're so important and they go together.
That's amazing, Maria. So thank you very much for sharing that. So you said there are three main pillars, and we talked about the first one last time, didn't we?
Yeah, we
talked
did.
About insurance, and then you said, okay, lasting power of attorney, and then will. So things to put in place when you're alive, things to protect your wealth when you're dead. And it's interesting, because you can't take it with you, but it's interesting that
Absolutely.
you can still make your wishes known, even though you're not going to be there. So
yeah.
Can you just break down these three pillars a bit more for us and tell us like what we should be doing and how to make sure that we are on top of everything in these three pillars?
Okay, so I'm just conscious because if I talk about insurance, that's quite a wide topic, and lasting power of attorney kind of needs to sit by itself as well. So I wanted to touch on the three areas because they should all be considered when you're looking at planning your estate. But and I will look at all of those with a client when they come to me if they want to make a will, because they all work together and they're all very important. I think what I'll touch on is the considerations and the things that I will ask my clients to think about if they're not sure about making a will or what they need to think about. And what does a will do? So what is a will? A will is a legal document that allows you to choose what happens to your assets when you pass away. And you would choose executors, so two people, minimum of two people that you would trust in order to execute legally your wishes on your death. Now, more commonly, those two people may be adult children, but I like to challenge the norm and say they don't have to be your adult children. They can just be people that you trust. So they can be your siblings, close friends, or relatives. But the absolute key is that they are people that you trust and who will be able to execute your wishes when you've gone away, when you've died. But you get to choose who inherits, when and how. You get to choose. And when you think about who inherits, what are they inheriting? They're inheriting what you have worked really hard for while you've been on this earth to leave something behind for when you're no longer here. You're leaving a legacy, you're leaving wealth, you're leaving, your name or whatever memory it is that you want to leave behind. Importantly, you choose what happens to your children. And it always strikes me when I meet people who have children and they say, I haven't made a will because I don't have anything to leave behind. You have children, and that's really, really important for you to think about. God forbid if you were to pass away, what would happen to your children? Who would look after them? It gives you the control and the consideration to think about, if you were to pass away and predecease your children, what age would you want them to inherit? Because they would automatically, by law, inherit at the age of 18. I don't know about you, but 18-year-olds nowadays may be quite vulnerable, and their mindset may not be able to manage, you know, the amount of money that they might inherit as part of somebody's estate. So that's again a consideration. You get to plan for disabled or vulnerable children, what would happen to their inheritance as well. If you are living in rented accommodation, you get to think about, you know, tenancy, because it's not automatic that tenancy would be transferred between one family member to another. So it could mean that you're avoiding rendering a family member homeless. You get to choose who you might want to exclude. And I know that's, what some people might not want to talk about out in the open, but there are people who exclude individuals from their will and want to make it really clear as to who would inherit and who doesn't. You get to think about what might happen to your pets if you have pets that are beloved to you, and you look after them. What will happen if you pass away and you're their main carer? The reason why we talk about insurance and lasting power of attorneys as well is because when you think about estate planning, you get to think about care funding, and that's really important to protect any wealth that you have while you're still here, so that when if you lose mental capacity, that the inheritance that you had planned may not be eaten away into care funding. It's so vast, you get to think about who would occupy your property when you pass away. It avoids conflict. It eases the burden. It takes away assumptions because you leave instructions. You can be strategic and plan for generations to come. And it avoids the rules of intestacy as well. And if you haven't heard about the rules of intestacy, the rules of intestacy is a law which states if you haven't left a will, who would, which lineal descendants you have that would naturally inherit what you leave behind. And it goes right down, through all of your lineal descendants. And if there is nobody left, it will go to the crown. And we've all seen programs such as Heir Hunters where they're looking for, distant relatives and descendants of individuals so that they can inherit. Because if not, it will go to the crown. And I don't know about you, but I think King Charles has enough. So
yeah, that's amazing. That's interesting. And Maria, thank you. But assuming you don't have a will, because many people don't, right?
Yeah, that's right.
Assuming we don't have a will, then what happens? What is the process if someone dies?
Yeah. So if somebody dies without a will, again, it depends on what their net worth is in relation to whether or not it would go to probate. If they have a very small estate, and it's unlikely that probate would be needed. And a grant of probate, just for people who aren't aware, is where you would need to be granted the permission really to sell assets and release funds from financial institutes. And the financial institutes would need the grant of probate, which is a legal document to allow the executors of the estate to do so. But as I've just stated, the main issue that would happen if somebody didn't have a will is that their assets would fall as per the rules of intestacy. So, for instance, if we have spouses and one didn't have a will, then the surviving spouse is entitled to the first 322,000 of that individual's estate. And then the rest of the estate, the rest of the value of the estate is shared 50% with the spouse and any surviving children. Okay, so again, you lack the control really to plan, because that might not be what you want as an individual. You might want the majority of your estate to go to your spouse, so that they can live comfortably, and then go to your children. It avoids conflict, because if people don't know what the individual could want, they're making assumptions and they might not actually be accurate. I've had situations where families, the matriarch of the family has died without leaving a will, and the children don't know whether they wanted to be buried or cremated. So they're squabbling because they want to do what's right for their parent. They actually don't know. So two thought that the individual might want to be cremated, two thought that they might want to be buried. And you know, while they're grieving, there's conflict. So that they're the major things that happen. And I think we've all got stories, haven't we, where we've heard of somebody passing away and conflict kicks in very soon. And that can happen with a will, but it happens more often than not without a will.
Yeah.
Um, sorry, just being clear on the question as well. If you are parents and you pass away without a will, or a single parent, let's say, you know, there is a risk that children could be taken into care while it's established who would be awarded special guardianship for the children if you haven't stipulated in your will. Whereas if you leave a will, whoever you have listed in your will as the guardian of your children is who, you know, the children would go to much quicker than without a will.
Yeah. So it's interesting. You talked about children, and I want to ask, in our generation now, there are loads of blended families, right?
Yes.
And it's very common for, you know, different families to come together in marriage and now be blended. Should a parent have, you know, maybe parent A has 3 kids and marries parent B who has 3 kids, and they're now a blended family, and parent A and B have been married maybe 5 years or 6, 7, 8 years,
Yeah.
and everyone lives happily. If
Mm-hmm.
one parent dies, what happens without a will? What happens
Mm-hmm.
to the stepchildren
Mm-hmm.
of that parent? Does it does the parent,
Yeah.
other parent,
Okay.
keep
Yeah.
hers or his?
Yeah. You're talking about the sideways disinheritance trap, Elizabeth. So that's something that I often talk to couples about, whether they're, you know, whether they're married or not married. But I must say that within the law, there's no such thing as common law. Okay. So I just want to touch on that first. So if you are not married and you have children, so if you're not married in this country, it's not recognized. So it's not an automatic that because you've been living with somebody that they would inherit 50% of what your wealth is. That's absolutely not true. There's no such thing as common law. But what you've touched on there is a very, very key situation that tends to happen, the sideways disinheritance trap, excuse me, which can happen whether you have a will or not. And it's based on the type of will and how your will is structured. So if an individual has a basic will which leaves everything to their spouse, and let's say then to their children, and they pass away, their spouse would inherit everything. If spouse A, as you said, then remarries, and you know, then they have a spouse, let's say spouse B, and then spouse A passes away with the children from the previous marriage still alive, and then that everything that they had inherited from the first marriage would go to the second, and their children would get nothing. So that's a real key situation where a trust may be discussed, and I would advise what the clients want to happen if either of them were to pass away. And we really do look at scenarios. You know, I really do ask my clients, what do you want to happen if you pass away first? What do you want to happen if you pass away first? And what would happen if you both pass away together? So that all of those things can be considered. And that's where we may discuss potential trust to protect for the ultimate beneficiaries. Now, I must say, with putting a trust like that in place, which is called a property protection trust or a life interest trust, that property in the first instance would need to be purchased in a different way. So as tenants in common rather than joint tenants. So we really look deeply as to how you've purchased your property, how much is still owed, how, you know, who owns the majority, etc. We also talk about, you know, children from previous relationships and children outside of marriages as well comes up. So, you know, there's no judgment when you're talking to me about planning your estate. But the more I know about your family setup, your blended family setup, the more I can advise you so that it's efficient and it's adequate for the needs of your family and what you want when you've passed away.
That's so amazing. Thank you so much for sharing that. And you know, the different types of trust that one can set up in order to ensure that, you know, the inheritance is passed on in the right to the right people.
Yeah.
But before we step into trust, while we're still on wills, can we talk a bit about the costs of not having a will? You already touched on probate, maybe just explain a bit more for those who don't understand what exactly probate
Yeah.
is and the costs associated with that. Like, is it free, or maybe it's not free? And then the taxes associated with not having a will on someone who has, property, money.
Absolutely. Yeah. So in the first instance, we all have an inheritance tax threshold of 325,000. That's what the government gives us. That is tax-free from HMRC. But if our assets fall underneath that threshold, there is no tax to pay whatsoever. However, for assets that rise above the £325,000 threshold, there is potentially 40% tax to pay. And that's paid on death to HMRC. But there are some caveats on that, because the majority of households in the UK may not be eligible for inheritance tax, but because we're all aware that we have this 325,000, and if not, then it's 40%. Everybody wants to run away from the 40%. But there are spousal exemptions. So if you leave, you can leave everything above 325,000 to a spouse that you're married to, and it's free of inheritance tax. Most people, until they speak to me, are not aware of that. If you leave property to a child or a grandchild, even a stepchild or a foster child, then you can have an allowance that raises up to 500,000, let's say. So when I advise clients, we look at your net worth, we look at all of your assets and how much it's valued at, and then I would tell you, where your risk is, if you're open to risk from inheritance tax. So in clear English, if you have an estate that is worth 500,000, then you are £175,000 above your inheritance tax threshold that you would be eligible to pay 40% on. And quick maths, that's £70,000 that you would be eligible to pay in inheritance tax for the 175,000 that you're over your threshold, which is something that we wouldn't want to pay out without a fight, right? So that's where I come in. I'm able to sit down with you while you're still here, while you still have control, when you can consider everything that you have or you're planning to have in place, so that we can make sure that it's sufficient for the ones that you're leaving behind, which is really, really key. And also, look to avoid probate, because there are costs involved with probate that would be paid by the executors, normally from the estate, for administering probate process, and that can be anything depending on the size of the estate. We're looking at around £3,000 minimum.
Yeah. Thank you so much. So that's interesting. So it's good to have your plan set out, because you can find out how you could be exempt from inheritance tax, and also it will helps you keep more of your money.
Yeah.
You're not paying out fees in probate, and you're not paying out unnecessary taxes.
Can I also, sorry, Elizabeth, also a point that I forgot to mention as well, is it could be as simple as your estate is under £325,000, but you have a £200,000 life insurance policy that isn't placed in trust. Now, if your life insurance policy hasn't been placed in trust on inception, then that could leave you open to going over your threshold without knowing it. So one of the first things I do with my clients is to ask them if they've got any life insurance in place. Can I review it? Can I have a look at it, whether it's fit for purpose, number one, but also, is it in trust? And if it isn't in trust, I will support my clients who come to me for a will to place their insurance into trust, so that it doesn't take them over the inheritance tax threshold. And why should insurance be tax-free? It's a tax-free lump sum that you're leaving to your loved ones on your death. So it shouldn't be, it shouldn't be exposed to tax, and it should be the first thing that pays out, that allows your family and your loved ones to have those funds to even pay for your funeral if need be.
Yeah, amazing. That's a very good point. Okay, so now we're talking about trust, right? We know we should put our life insurance in trust. You just said that. So tell us more about trust. What is a trust, Maria? For many people who are wondering, like, what am I trusting?
Yeah, absolutely. So a trust is an arrangement. It's a legal arrangement, or you can even class it as a vehicle where you can place money or property into a trust, and then whatever you place into a trust, whether it's money or the property, becomes the responsibility of the trustees that you have appointed. Now, you can be a trustee of your trust, but you should also have at least another two minimum trustees who would look after what's in your trust, especially, and it all depends as well, because there are lifetime trusts and there are trusts that you can put in place that kick in when you've passed away, so will-based trusts as well. So that's ultimately what a trust does. It's important to remember that when you place anything in a trust, you no longer directly own it. So I get a lot of queries, Elizabeth. I don't mind don't mind telling you this. There's a lot of noise out there at the moment on social media about placing your assets in trust. And, unfortunately, a lot of the information out there has come from overseas. So I get a lot of queries, I want to put this in trust. I want to put my house in trust. And when I ask my clients, what is your objective? What's your motivation? It's to avoid inheritance tax. Okay, so let's look at what your assets are worth, what your net worth is. Okay, well, actually, you're not even liable at the moment for inheritance tax. So let me just give you the pros and cons of using a trust. So what people tend to forget is that when they place something in a trust, they no longer own it. Now, you can have a property that you have on a mortgage, and you may be able to place it into a trust, which is great, but then you won't be able to, or it's very unlikely that you'll be able to raise equity on that property if you want to do so later. So, and trusts can be quite complicated to exit once they've been set up. They can be quite costly to set up. So it's really, really important that when if you do go down that road, you've taken the right advice, you've been very well informed of the benefits and the pitfalls, the potential costs, because trusts don't come without cost implications as well, depending on the way it's been set up. And also in a lot of instances, you can then lack control of an asset, funds that you actually might need to have control of later on. So again, it's something that shouldn't be taken lightly.
So it's important to know your objectives. What
Absolutely.
are the objectives with putting this in trust? Because once you put it in a trust, it's not something that you own anymore. The trust owns it, even though it might be something that it's in your name. May I ask, Maria, what are the different types of trusts? What type of trust are there different types of trusts?
Yes.
Life insurance policy
excuse me,
versus a trust that maybe that you would put property in, or is it the same?
Really good question, Elizabeth. There are many, many different types of trust, and trust can be complicated and it can be quite confusing. I'll talk about the four main types of trusts that I advise clients on when we're talking about their estates and looking at their will, because there's even different types of trusts that you can consider when you're looking at your life insurance. So the first trust is called a bare trust, and that's a trust that most parents might include in their will. And that's where they would be leaving funds or an asset to a minor, so somebody that would inherit at the age of 18, but they're not at that age yet, so it needs to go into a trust. And they would normally do so with a letter of wishes, which is, as it says in the name, it's a clear letter of what you want to happen to those funds if you were to predecease your children. So you would be leaving the letter of wishes to be adhered to by the guardians of the children and the executors and the trustees to ensure that your wishes are executed. So it could be that you want the funds within the trust to be used for education purposes and so on. But a letter of wishes can even be as prescriptive to say, that you want your children to continue to attend certain religious studies, whatever you want can go into those letter of wishes. But the main purpose of that trust is to look after funds or property until that minor comes of age. Normally at the age of 18, they're entitled to have some of the funds or all of the funds released from that trust. So the second type of trust would be a discretionary trust. And it's called discretionary because it's really at the trustees have control of whatever you have placed in that trust. And it means that the beneficiaries are not necessarily entitled to inherit. It gives the trustees flexibility to make changes if need be, and that can protect your assets if any of the beneficiaries were to become vulnerable You know, and when we talk about vulnerability, we're not necessarily talking about disability. We're talking about people who might be vulnerable in terms of mental health, vulnerable in terms of drug or alcohol abuse, and therefore, you know, them having access to large sums of money in relation to that trust might not be sensible. Um, Again, I've just seen a question come through. What about monies from a pension? Yeah, you can speak to myself or a financial advisor about placing some funds from a pension into a trust. Also, again, there's lots and lots of ways that you can consider what you might want to happen to that pension, you know, in your life as well as when you've passed away. Um, so sticking to a discretionary trust, the main thing to remember there is it gives the trustees flexibility to decide who or how and who and when the beneficiaries inherit. So the next trust would be a disabled or vulnerable persons trust that allows parents or carers to leave funds for somebody who's disabled or who might be in care. And that really also allows the trustees to have control and be flexible, because as things change in society, the individual, the main beneficiary, may need to have more funds released. So it's not as prescriptive as, you know, as other trusts can be. And again, a letter of wishes would accompany vulnerable persons trust or disabled trust, so that the trustees can know exactly what the wishes are within that trust at the time of set up. And then we've got life interest trust, a property protection trust that we've mentioned before, which would allow you know, people who own property jointly, or, you know, to ensure that part of that is ring fenced for the ultimate beneficiaries. It can allow a surviving spouse to live in a property and even rent out rooms, even downsize, but still have funds from the trust to live on in their lifetime. But ultimately, the part of the trust and the part of the inheritance that came from the deceased spouse would be ring fenced for their children or their ultimate beneficiaries for when the second spouse passes away. And as I said, for that trust to be to go into place, you would have to potentially do a change on land registry if you own the property as joint tenants, and to move to tenants in common in order for that to work.
Amazing. Thank you. I'm just taking notes, scribbling as quick as I can. So that's great. So, Maria, question. I'm having a scenario in my mind, right? Let's say I am in my 50s and I have life insurance of maybe £500,000. I have 3 children, currently all on, maybe one is above 18 and 2 are under the age of 18. I have elderly parents as well, and I am financially responsible for them. If such a person with that description should pass away, what would you have advised that person to have put in a will or in a trust to ensure that his or her adult son is taken care of, and the younger children are taken care of, and the elderly parents are also being looked after in a way?
Yeah, really good question. So again, and yeah, what I should have said initially as well, that is that every single situation needs to be tailored towards your family situation, and that would potentially class as somewhat of a complex case, because there's so many different scenarios to look at. And definitely in that case, I would advise on different types of trusts. So if there is minor children, definitely a bare trust. So, you know, a trust to be put in place for minor children with a letter of wishes. Guardians would need to have been selected to ensure that, you know, if you predecease your children, you have made a consideration as to who the children would live with. But what comes up quite commonly is a lot of my clients haven't considered, you know, what would happen to the house. So I don't want to digress from the question, but this tends to come up a lot. So I normally would have, again, clients that are in their 50s or 60s. They have multiple children, some of which don't live at home, some of which have, you know, have had good starts. They're married, they have their own homes, but they would sometimes have adult children that live with them at home. And then they say, well, I'd like when I die, for the property to go to all of my children in equal shares. And that's great. And I say to them, okay, so what about the children who live with you still? what do you want to happen to those children? Because if the house is, as you've instructed, if the house gets sold and is split equally, based on the value of the property, do you think that the child that lives at home is going to have enough of a deposit to be able to buy themselves their own home? Are they going to want to leave the family home? So there's lots of things that people don't consider. So another trust that I didn't touch on was a right to occupy trust as well, which allows parents or homeowners to, leave instruction as to who they're allowing to occupy their home until a certain point they can have it for 2, 5, 10 years, or for a lifetime of the occupant, or until they choose not to live there anymore, or marry or pass away themselves, and then the property is sold. Okay, so there's another other scenario there. So in your scenario family, potentially a right to occupy would be considered if they have adult children who live at home. But the trust can be set up with funds to be released. So if the parents who they care for have a level of financial dependency on them, then funds could be released so they can still leave provision for their parents to be cared for and funded for within a trust as well. So there's lots of different scenarios that we could potentially look at for that family.
Yeah, that's very interesting how different trusts are required for different types of scenarios.
Yeah.
So if you do have any questions, do put it in the chat. And Maria and myself, we will go through those questions. But I wanted to ask before we run out of time, lasting power of attorney, what is that?
Okay.
And why is it important?
Okay. So a lasting power of attorney is something that is a legal document, a government document that you would put in place in your lifetime while you have mental capacity. And you would be placing a lasting power of attorney in place it's a precautionary document, just in case you were to lose mental capacity. Now, a lot of people assume that if they have a joint bank account with a spouse, that if they were to lose mental capacity, it's fine because their spouse would be able to have control over their half of what's in the bank account. And that's untrue. I'm not sure if you watch GMTV or any of the attendees watch GMTV, but during COVID, one of the GMTV presenters, Kate Garraway, made having a lasting power of attorney a real topic, and Martin Lewis has since continued to do so, and it's really helped because I get a lot more queries on lasting power of attorneys. But what Kate Garraway did was she brought to light that even though she was in a marriage, unfortunately her husband, who's recently passed away, he was in a coma due to COVID, and she had no control. She wasn't able to access any of their joint bank accounts. She wasn't able to remortgage, and she wasn't able to access anything they had in joint names. And what people need to remember is that when somebody loses mental capacity or they are incapacitated, so they're not able to make their own decisions, they have a protected characteristics by law. So the banks and the financial institute have a responsibility to protect, whatever finances they own. So, and that's why the other spouse wouldn't have control or be able to access any of those funds unless you have a property and financial lasting power of attorney. So there are two lasting power of attorneys. There's one for property and financial, and there's one for health and welfare. Property and financial lasting power of attorney allows you to do everything that the individual, the donor, as we call it, can do. Buy and sell property, access bank accounts, invest, pay bills, everything that the donor can do. If they lose mental capacity, or with their instruction, if they have mental capacity, but let's say they lose physical capacity, in a situation. The health and welfare lasting power of attorney allows you to choose who would advocate for you and your medical wishes should you need life-sustaining treatment. And that lasting power of attorney is only to be used if you lose mental capacity. So that is a purely precautionary document. Both documents can only be instructed while you have mental capacity. So if you are losing mental capacity, unfortunately, you've lost that element of control to then choose your attorneys And, you know, what happens then is that your loved ones may have to go to the court of protection to request a deputyship to be able to, you know, take control and support you and to make decisions for you. And you're looking at a minimum of at least £2,000 at that point, because all of the medical and mental capacity assessments need to take place, which you don't have to have at the time when you do it, when you have mental capacity. It then becomes my responsibility as the certificate provider to vouch for your mental capacity when you put the lasting power of attorney in place. So they are becoming much, much more popular now, because people, you know, are being able to testify to what happens when you haven't got a lasting power of attorney in place. It just gives you choice. It gives you the right to choose people you trust to advocate for you and your assets and your funds and your health, you know, if anything were to happen.
So thank you for sharing that, Maria. So just to clarify, if with the made up scenario, if
Okay.
if a wife has a husband, right, and maybe one or the other fall ill, they are in a coma, for example, and they are there for, I don't know, months.
Mm.
Now this person in the coma is the main breadwinner, right,
Yeah.
in the family. They pay the mortgage, they pay the fee,
Mm-hmm.
they pay all the bills. If there is no power of attorney, can the wife go to the, or the husband go to the, you know, the spouse's bank and
Mm.
get money to pay the mortgage or get money to pay fees?
Okay. The answer would be no. They would have to go to the court of protection and apply for a deputyship in order to produce that to the financial institutes to then take control. That can be a very costly and long process, a time in which you're already dealing with emotional anguish and financial stress. So the answer to that is no. The lasting power of attorney is the only thing that allows you to have that level of responsibility and power. Needless to say, as well, in that scenario, without a lasting power of attorney, the medical professionals can make decisions for your life-sustaining treatment based on, you know, how they deem, what they deem to be, you know, within the best interests of you as an individual. Whereas if you have a lasting power of attorney for health and welfare, it's your attorneys who would have the final say over the medical professionals as to what would happen to you in that situation based on your best interests as an individual that they know. So it's, you know, what I like to think about when I'm supporting families to place lasting power of attorney into place, I encourage them to have conversations and we discuss what would happen if there was a situation of somebody being in a situation of needing life sustaining treatment. What would they want their family to do? What would they want them to have considered? And what would their wishes be? And we have that conversation. I encourage them to have that conversation once in life, so that, you know, their attorneys are not unsure if that were to ever happen. And again, we would touch on potential religious beliefs as well, and, you know, the wishes and obligations of individuals as well.
Amazing. Thank you so much, Maria.
Mm-hmm.
Okay, let's look at some questions. Okay, so someone asked about monies from pension. Just to I know you already answered that question, or variation of that. If a version of that question or would be, if I have, or if a partner has a lot of pension, maybe the main breadwinner in the family has a lot of pension, and they want to make sure that, you know, if they die, their children, their spouse, or relatives have access to that pension. Is there anything that they need to do to protect that pension so that it goes to a partner, or I don't know, maybe the person is married, maybe not married?
Yeah. The main, again, this is a tick box exercise that I do with all of my clients. And I ensure that number one, I get them to check all of their pensions. I think the way I describe it, when I am approached by a client who might want to talk to me about financial planning or look at a will, there's a 360 that I will look at, as well as look at insurance. I will ask them, what about your What about your pensions? Where do you have pensions, and what are your pensions potentially worth? And a lot of the time people aren't sure where they are, they haven't looked at them. So I'm getting them to look at their papers and finding where all the paperwork is, and doing their sums and adding up where everything is. But one of the key things that I get them to do is to contact their employer to ensure that their employer has an expression of wishes, because that's something that you should have on inception of a pension, is stated who would benefit from your pension, be it a spouse or your children at that time. It is normally defaulted to a spouse, but some people can have it go to their children. So that is one of the main checks that I get them to do during the process of writing their will, to ensure that it is going to be exempt from tax, because they have made an informed decision as an expression of wishes.
Oh, amazing. Thank you. I think
Yeah.
that clarifies that question.
Yeah.
So
and I think I saw the question come through, which I wanted to also touch on as well. If you do the expression of wishes, that will also ensure that that's exempt as well, because it will go directly, very similarly to insurance, it will go directly to the beneficiary outside of the estate. Yeah.
Amazing. Thank you so much. And then the next question is a trust advisable if your children are adults? Or any advantages for inheritance purposes, please?
Is a trust advisable? Again, I'm not going to talk myself out of, because trusts are expensive to set up. They can be expensive to set up. So, I have clients who come to me and they might only be eligible for a simple will. But when I dig deep and find out their family circumstance, that's when I might be advising of a trust. But what I want to say is that most clients don't need a trust. When I look at the way their families are set up, and I look at their inheritance tax liability, they don't need a trust. But some people still come to me and they want it, and that's their choice. So, but what I want to say is I'm not going to upsell on a trust if a family doesn't need a trust. What I am going to do is discuss the benefits and the pitfalls of having a trust. So go back to the question for me again. It was around adult children.
Yes.
Adult children.
Yeah.
So in that question, it would depend. So if your adult children, are they living at home? What is it you want? What is your ultimate? What is your ultimate objective? If you want your children to inherit, you could use a life interest trust, which allows children to have proceeds of the trust at times when they need it, managed by the trustees, and the trustees can also be the beneficiaries. But in that scenario, we normally insist that, so for instance, if you have a trust and there are two children who are the beneficiaries of the trust, we would advise that those children can be trustees, but they should also be a non-benefiting trustee as well, just to avoid from conflict of interest. So you can set up a discretionary trust, which would mean that that whatever assets you have are in trust for those adult children, and those children can manage that trust, which can be, depending on what's in the trust and the value of the trust, inheritance tax efficient, because trusts can last for 125 years. But again, what I would say to clients is using a trust can be restrictive because you can't always access what's in the trust. Trusts can sometimes be difficult and costly to revoke. And you lose some control, because let's say if it's a property that you're placing into a trust and something happens later down the line and you may want to release equity from that property, there can be restrictions. So if there's a mortgage on that property. So again, you'd have to look at things in their individual situation.
Yeah. And
so what can be money can be placed in a trust.
Yeah.
So anyone can place up to £325,000 in a trust at any time, and that will be free of any inheritance tax. But what you've got to remember is if there is inflation and whatever funds you've placed in a trust appreciates, then you'll be liable to pay the inheritance tax on the difference. Some trusts have exit fees, which again can be costly, depending on the amount that's in the trust. And some trusts can have periodic charges, which can be up to 6% every 10 years of what is in that trust. So again, it all depends on the type of the trust. how much and what you're putting in the trust, the objective and how you want the trust to be managed, as to then how I can advise you on what trust is right for you, how you should set it up, and how you can potentially set it up for your beneficiaries to have to exit from that trust as well.
Yeah. May I ask a hypothetical question, Maria?
Sure.
If, let's say, I have properties and maybe the properties I envision, maybe I would have paid off all the mortgages on the properties. Maybe the properties all come to value of like £5 million. And I'm thinking of my kids and my grandkids in the future. And I want to make sure that my children are provided for and my grandchildren are provided for. Now, would you suggest that, and maybe I have life insurance, maybe the life insurance is also like 600,000. Would you suggest that I just need a will to manage these assets and life insurance and maybe a lump sum cash, from my bank accounts? Or would that be a trust for that type of assets and cash?
Yeah, good question. So in that scenario where I have high net individual clients who have assets and wealth, over the inheritance tax threshold, and it's very difficult to minimize and mitigate the tax situation in that situation, and they are going to pay way more than 40%. So that's when I would work very closely with a wealth advisor, because those type of individuals need to understand the level of inheritance tax that their loved ones are likely to pay. And often it can be £2 for every pound that they own. And then it's really, they might want to think about selling assets off. They might want to think about potentially doing transfers of equity where they own assets jointly with children or loved ones to then mitigate what they own in terms of moving things out of their own estate. Particular trusts can be set up, again, with partners of mine, independent financial advisors, such as loan trusts and various different financial trusts. So again, without sort of, diverting from the question, it depends. I've had high net worth property investors who understand how much inheritance tax their loved ones are going to be liable for. And they have said, well, I've taken the time to build the wealth. If my loved ones have to pay the tax on what I'm leaving for them, then I think that's a small price for them to have to pay. And I have had high net worth individuals who want to avoid paying a penny of tax. And then I would work with a wealth advisor alongside to have them look at strategies and vehicles in order for them to make decisions that are tax efficient during life, rather than waiting until the inevitable and leaving their loved ones with huge tax bills. So it's down to it's tailored, it's individual, it's not one size fits all. And it has to be very carefully considered based on, we look at your property values, your net worth, what you owe versus what you don't own. And also, when I'm talking to clients about a will, I look at what they're also thriving to own and what they're thriving to do. And also, we haven't even touched on business, whether they have a business asset as well, which is worth quite a lot of money, and if they have a business partner interest as well. So there's so much to consider when making a will. My will questionnaire is extremely long. There's lots of questions that clients have to answer, so that together I can advise them, adequately to make the right decisions that are right for their legacy and what they want to achieve ultimately.
Yeah, thank you so much for that. That was a great answer. Okay, something just came up here. I thought pension is exempt from inheritance tax.
Yeah, as I've said, yeah, it should be exempt from inheritance tax because it's held outside of your estate, very similarly to insurance. However, you do have to have given the name of your beneficiaries on the inception. Most pension companies, and employee pensions will have sent you a form where you will have filled out when you started working, and you will state who your beneficiaries are of your pension. I always get my clients to just check that, make sure they're still happy with it, and check that that's been filled out, because that's how you make it exempt.
Yeah. Great, thank you.
Yeah.
And I think you answered this already. I'll just reread it. Do trusts have expiration terms? I think you answered that. And can an existing trust be amended at any time? Okay, you answered.
Okay. Trusts do have, you can set expiration dates or exemption terms in a trust. So, for instance, a right to occupy trust, which is where you are allowing somebody to live in your property after you've died. You can set whether that's for 2, 5, 10 years or their lifetime, or until they remarry, or until they choose not to live there. Trusts will normally last for 125 years if you don't set, if you don't set an exit. And some trusts can be revoked much easier than other trusts. So again, one of the things I establish with clients is how sure are they on the decisions that they're making at this point, because some trusts are more flexible than others. And again, that's about me giving the benefits and the pitfalls of each trust that we're talking about and that we're discussing at the time.
Yeah, amazing. Thank you. And I think you answered this as well. Any other assets that can be placed in a trust apart from property to minimize inheritance tax? I think you said cash.
Yeah, cash, even things like fine art, luxury goods, yeah, things that are things that we look at in terms of wealth. Yeah, any luxury goods or anything that's worth any wealth.
Yeah,
Yeah.
amazing. Thank you so much. If you have any more questions, you can put it in the chat. But apart from
Okay.
that,
I've got another question that's come in. Can you
yeah.
express your wishes in writing with a power of attorney? You can leave preferences and instructions in a lasting power of attorney. And again, as the certificate provider, I advise my clients on what preferences and instructions they should or they can leave in a power of attorney. I often include some preferences and instructions for my lasting power of attorneys for my clients, which are standard within industry that I know allow their attorneys to have a bit more responsibility, and it removes some ambiguity. So the answer to that is yes, but you have to be careful, and you have to understand. You have to look at the benefits and also the drawbacks of some of these options and preferences. You really should look at being advised on a lasting power of attorney, although you can do it yourself if you're confident online on the .gov website, but you should really look at and have an understanding of what you're doing.
Yeah.
Before we go, Elizabeth, if you don't mind, I just wanted to share my contact details with everybody, and also potentially offer a discount if that's okay.
Yes, please do.
Yeah. Okay. So let me just have let me find. Can you kindly allow me to share my screen?
Yes.
Thank you.
And while I'm doing that for Maria, please put in the chat a 1 if you have gained some knowledge from this class. Just put a 1 if you've gained something new. And let me see. And then, oh, I'm getting ones. Great, thank you. And as we always do in our masterclasses, we always share what we've learned. Why? Because someone might have missed something that you picked up, and that way we are sharing information. So please, if you gain something, can you put something that you've gained in the chat as well? What you've learned, anything that you've picked up, any new tips, and that can help someone else. So let's be a blessing to each other that way. So yeah, 1, it's been exceptional. Yes, thank you, Maria. It has been exceptional. Maria, as just before you explain that, can you explain the term settlor?
Settler. Yeah.
What is the responsibility of this role, please?
Okay, so a settler is the individual who is setting up the trust. Then you have the trustees who have the responsibility of managing the trust. And actually that it's great because there's so much to touch on. There's so much we didn't touch on, Elizabeth. And that's a really good point to stress that the trustees, their responsibility really lends itself almost to a director of a business. They need to keep accounts of what's in the trust. They need to account for what's in the trust. They make decisions as to what comes out of the trust. And they're really accountable. So yeah, the settlor is the individual who is placing whatever it is into the trust, and the trustee is the one who manages that.
Yeah, great. And you've said
Yeah,
different types of people could be trustees. You said that.
different types of people to be trustees, but the decisions shouldn't be made lightly. They need to be people that you trust. It goes in the name trustee, but also people who have the capability to make those decisions and take on the responsibility. As I said, a trust can last for many, many years. And yes, the trustees can be the beneficiaries, but you know, like anything to do with assets and money, it doesn't come without conflict. So that's why we always look at who clients might be considering to use as trustees, and then we might say, think you need to have somebody who is a non-benefiting trustee, who doesn't have a conflict of interest in what is inside the trust, just to account for any of that happening, any conflicts or any disagreements happening.
Amazing. Thank you so
It's
much.
just, yeah. So I want to offer all of the attendees or referrals. So if you choose to send the video on and they weren't present today, but they watched the video, and therefore they become a referral, I'd like to offer 10% on any services that you take out, whether that's a will, a lasting power of attorney, and the offer is valid until November 2024, the end of. So I just also want to share my by all means, review my businesses review Google page. We forgot to mention the name of my company, didn't we, Elizabeth? TTC Financial Consulting Limited. So by all means, review the website, have a look at my Google page. If thinking about a will is something that you're on the fence about, have a conversation with me. Same in relation to a lasting power of attorney or trust. Here are my contact details. You can scan the QR code and it will take you to my electronic business card. If you fill out the contact details, I have some information booklets that I would send you, some frequently asked question booklets, some booklets on the difference between an executor and a trustee. So lots of information that I'm happy to send out free of charge because you've taken the time to attend Elizabeth's masterclass today.
Amazing. Thank you so much, Maria. All right, we have another question. Do you have a minute for this?
Okay.
Okay. What happens if tax laws regarding trust change in the future?
Very, very, very good question. Because and because we've recently changed government, and even this week I read that there are talks for the Chancellor of the Exchequer to abolish the residential nil rate band. We didn't even touch on that today, but that's where spouses can leave, even up to £1 million worth of a threshold of inheritance tax, as long as they're leaving it to each other. And I was informed that they're looking at abolishing that, but making it so that couples can have an inheritance threshold of 500,000 each, still the minimum, the million, but abolishing the residential nil rate tax band. So the answer to the question is very difficult. What I do in anticipation of writing a will for a client is I can only consider what's happening now and potentially what might happen in the next 5 years. So when I'm making a will with a client, I'll talk about their future plans. I'll talk about what their net worth is likely to be based on their plans now in the next 5 years. And then we'll look at the will and base it on that, not on those figures, because things are subject to change. And with everybody who has a will, I encourage them to review it every 5 years, because life changes. People can be in a marriage when they make a will at one point, and then they could be divorced. And there's different advice I'd give to people that are divorced, and as well as when people become widowed, because your tax exemptions and your threshold can change whether you're if you're a single person. It's different to when you're a spouse, to when you're a widow, etc. So good question. I don't have a crystal ball, but I do look at between now and the next 5 years and advise you accordingly.
Yeah, absolutely. And Maria, do you advise on mortgage refinancing and HELOC?
Do I? So no, I'm not a mortgage broker, but I do work very closely. So I'm in the finance industry. I'm a protection advisor, so I work very closely with mortgage brokers. Clients often come to me in relation to having mortgage queries, and I work with three brokers closely who I refer to, who are very established and very experienced in their field. So by all means, speak to me, and I will refer you. I work very closely with solicitors and probate lawyers. Um, you know, just about to start a relationship with an accountant. So, I have a network of individuals that I work with who have the same level of integrity and outlook about and passion about helping our people as I do. So, if you're stuck and you can't find somebody, just ask a question. You never know.
Yeah. Okay, amazing. Thank you so much, Mariah.
No problem. It's been enjoyable. Thank you for having me, Elizabeth, as always.
Yes, it's been so enjoyable. We'll definitely get you back again. If you aren't subscribed to me, you may not get the recording of this session. So make sure you send me an email so that I have your email address and I can send you a recording. I will just drop my email address at the bottom. I hope you have taken screenshots of Maria's information. Should you have any questions, just send her a message and
Please do.
send her an email or
Yeah.
a text and let her know what your concerns or your queries are.
Yeah. And it's such a vast topic, isn't it, Elizabeth? We talk about that all the time. So if there's anything that people are not sure of or they want more clarity on, they can contact me directly, because as I said, it's tailored. It's difficult to give an overview to lots of people because it's very personal. But once again, thank you so much.
Yes, it is a huge topic. And there's so many things to consider. So it's hard to squeeze that all into an hour.
Yeah.
But we tried, we did well. Yeah, and then thank you so much, Maria. Adela says thank you. Really good session. Yes, amazing.
Thank you.
We appreciate you so much. And thank you each and every one of you for joining me this morning and in this session. Have a wonderful afternoon. Have a great day. And I just wish you an amazing rest of September.
Definitely. Thank you so much for everybody who joined. Appreciate it. Thank you.
Bye.
Thank you.
Thank you. Bye-bye.